think you have it upside down. Turn it over. Yeah, that's much better. Now you have to make it a little small. Too small, make it a little bigger. That's, I think, fine.
Start the time.
Good afternoon. My name is Kimberly Spence, and I respectfully submit that the Fourth Amendment of the Constitution of the United States of America was adopted in July 9th, 1868, as one of the original Reconstruction Amendments. Its Citizenship Clause provides a broad definition of citizenship that overruled the decision in Dred Scott versus Sanford of 1857, which held that African Americans could not be citizens of the United States. Under the 14th Amendment, citizens, no matter their residence, were automatically entitled to the constitutional protections by way of the Due Process Clause. The Due Process Clause, which makes most of the Bill of Rights applicable, prohibits state and local governments from depriving persons, individual or corporate.
You have a very short period of time. I suggest that you just get right to the issue that you want us to decide.
Okay. Of life, liberty, and the pursuit of property. The Due Process Clause makes the Sixth Amendment right to a fair trial and the Fifth Amendment right to protections against government authority applicable, which means that it would be legally error to dismiss any of my Supreme Court enumerations of error based on any evidence grounds asserted by Mr. Deagle. We are all aware that subpoenas to request the evidence, especially the audio recordings of the trial and depositions, were received by the court reporter, Ms. Hull, see the Sheriff's entry of service, and she has chosen not to release the evidence. Additionally, Judge Wright denied my motion to reconsider, which would require that the audio recordings be played back in my presence to prove that the transcripts had been changed and required that corrections to the transcript be made, OCGA 56-41F. Also, Judge Tom Campbell moved the contempt hearing to require the surrender of the audio recordings by Ms. Hull to October 21st, well after the Supreme Court's oral arguments, as he needs to verify the validity of the subpoenas. Finally, and of course coincidentally, the Supreme Court, denied May 26th my motion to supplement the record with the audio recording submitted on May 6th, and has since chosen silence on every admitted motion to supplement the record. If my constitutional rights were not obstructed, the evidence would prove that the judge abused her discretion in finding that Mr. Willis was a man of poor character and his conduct was negative, i.e. drug use, which is evidence in the audio trial transcripts, which she felt required drug testing, that he had a criminal history associated with a convicted cocaine dealer and brought Spencer around this convicted cocaine dealer, had abandoned us, had abusive behavior in the presence of our child, and all proven through the unaltered trial deposition testimony that you do not presently have, as well as lies regarding all of the above to social services workers, improper care of our son when he had contacted the swine flu, along with the more recent breathing and care issues pertaining to Spencer's allergies. Finally, the lies about his earnings. It is a clear abuse of the judge's discernment to find all of the above and still award shared custody for the reasoning of a healthy balance. Mr. Deagle stated that the trial transcripts was replete with evidence to support the judge's healthy balance discernment or theory. However, there were only two citations referenced. The first was Mr. Deagle using his own words from the vicarious testimony of the nanny, which he later used as transcript-supported trial evidence in his briefs of the nanny's testimony of my alleged shortcomings or limitations as a parent, even though the nanny never testified, which is on page 170 to 172 of the transcript, beginning with lines 20, which violates my Sixth Amendment right to confront a witness. The second reference, the judge's ruling or need for balance, the divorce decree, pages 238 and 240, and the trial transcripts, pages 180 to 181, beginning with the line 16, wherein the Honorable Judge Wright actually stopped the trial proceedings, threw down her pen, and yelled at me because I indicated that Spencer and I would be fine with or without Mr. Willis, and later used this as an example of my shortcomings and limitations as a parent, which violated my Fifth Amendment right against abuse of government authority. The Fifth and Sixth Amendment under the Due Process Clause also protects my right to write more than a 30-page brief or many briefs as needed, as the briefs include enumerations of error to be considered wholly and equally to prove error in my case, and therefore require a ruling be entered in my favor based on these errors and not as a form of circumventing the Rule 20 or Rule 24. The Due Process Clause also protects my First Amendment right to freedom of speech, which is contrary to Rule 29. So what do I want for Spencer? I want Spencer to grow up in a Christian-loving environment free from drug use and negative influences, i.e. drug users and convicted cocaine dealers. The court found in the trial that Mr. Willis not only had bad character, but he also uses drugs, has a criminal record, lied to social about all of this, and was bringing Spencer around a convicted cocaine dealer, as well as he had issues with caring for Spencer. Appellant asserts that this is only a mere trade-off because Mr. Willis has money. Appellant also asserts that a woman should know her place. So I want to be clear that my motherly instincts haven't changed. I still prepare home-cooked meals, care for and nurture Spencer, among other things. However, even as a woman, I have survival instincts, and those survival instincts kicked in right after Mr. Willis abandoned us financially. Spencer was 2 months old. My survival instincts told me then and now that the mortgage and health care insurance needs to be paid. Food and clothes need to be purchased. Spencer's education needs to be funded. These same survival instincts are telling me that I can't afford to play the meddling and blocking me from gaining meaningful employment game, which began prior to the trial and prior to any court filings, to ensure that I will lose the only job that I could find as a D6 employee, and also took, although I was overqualified and underpaid, game. The attempt to have my home foreclosed on, the attempt to have a psychological evaluated because I was speaking out about the obstruction of justice, which is against my constitutional rights game. The Due Process Clause of the 14th Amendment requires that each state provide equal protection of the law to all people within its jurisdiction. The due process applies to the above, and it also applies to Brown v. Board of Education of 1954, which overturned Plessy v. Ferguson decision of 1896. The Brown v. Board of Education held that separate educational facilities are inherently unequal. As applied in this case, separate but equal does not apply to a child without deviation when the child is living with a divorced spouse who devoted many years to creating a loving, nurturing home environment for them to grow up in. Separate but equal does not apply to the child without a deviation when the child is living with a divorced spouse who has worked to advance the other spouse's career and simultaneously sacrificed their own career for the betterment of the family. Separate but equal does not apply to the child without a deviation when the child is living with a divorced spouse who is seeking re-entry into the workforce. Separate but equal does not apply to the child without a deviation, and therefore the presumption that a child is better off to have a separate but unequal living arrangement is contrary to the best interest of a child. Insomuch, OGCA 19-16-5 I-3-4 provides legal reasoning for deviation, which includes extraordinary extracurricular activities and special child-related expenses such as food, clothing, hygiene, summer camps, lessons, travel, bands, clubs, athletes, and other activities intended to enhance the social and cultural development of a child. Moreover, the due process requires that the state of Georgia align its rules and laws with the Constitution of the United States of America, because the United States of America ruled in Mapp v. Ohio 367 U.S. 643 of 1961 that the constitutional laws apply to the state by the way of the Due Process Clause. You are an American before you're an attorney. You're an American before you're a Republican or a Democrat. You're an American before you're Caucasian, African American, Hispanic, Asian, or Arab. You're an American before you're wealthy, middle class, or poor. You're American before you're heterosexual, homosexual, or bisexual. You're American before you're a Georgian. The most basic thing that we all have in common is that we're all citizens of the United States of America. As citizens, we share the same hopes and dreams. We share the same hopes and dreams for our children, our children's children, and ourselves. Our men and women in uniform are dying in wars to protect and defend our most basic right to call ourselves American. My sister served in Iraq. My father served in Vietnam and the Desert Storm. My uncle served and died in Vietnam. No matter what your beliefs are about war, we have men and women risking their lives every day in service of our country. They risk their lives to protect and defend our most basic right to call ourselves Americans. You're American first. I'd like to suggest that we set aside our race, religion, sexual orientation, class, or sex. We are American first. You must volunteer to serve, and you should serve the country by protecting and upholding the laws of this nation before any other laws. You can protect and defend this country by requiring high ethical standards for yourself and others in your profession. You can protect and defend this country by treating your fellow countrymen and women with dignity, honor, and respect. And as women, as citizens, we should protect and defend our country first. If the courts choose to protect and defend America first, they will have no other choice but to award full physical custody, given the overwhelming and unaltered evidence. Thank you.
Thank you, counsel, and thank you, Ms. Willis. This court will stand recess until further order. All rise.